Welcome back. Attorney Andrew Bethel of Bethel Law, where we talk estate planning, finances, real estate, and taxes. Today we're focusing on real estate, but with a twist. This is a warning from an estate planning attorney's viewpoint. If you only remember one thing from this video, let it be this. Stop putting your children on title with you without proper legal advice. It sounds alarmist, but I've seen too many families face negative consequences. Many parents add their children to the title to save money, but in numerous cases, that decision costs the family more in the long run. Why? Well, let's dive in. Firstly, adding your children to the title of your home could be harmful to them in two main ways. Number one, capital gains taxes. When you add your child to your property title, you're gifting them a part of your house. This means transferring your tax basis over to them, leading to potential capital gains taxes due when selling. Simply put, they would owe tax on the difference between your purchase price and their selling price. But there's a solution. Instead of gifting it, let them inherit it. When inheriting properties, they receive what's called a step-up tax basis, meaning the new tax basis is the fair market value as of your date of death, not your original purchase price. This minimizes and in some cases eliminates their tax liabilities. I've covered this in detail before, so I'll link to that video below. Number two, property taxes. Here's probably the most painful consequence, yet the one most people are unaware of until it's too late. When properties transfer, they can be reassessed for tax purposes, and in California, this all but guarantees higher taxes. There are exemptions, but they come with conditions. A common mistake I see is when a parent adds a child not living with them to the title. To avoid a reassessment, the property must be the principal residence of both the parent and the receiving child. In every case I've seen, this leads to increased property taxes, which adds up year after year, especially if it's a house the parents owned for many decades. Why pay extra taxes when you don't have to? And number three, liability and cooperation. Adding someone to the title means shared liability. If either gets into legal trouble, the house could be at risk. Moreover, every decision about the property, from refinancing to selling, needs mutual agreement, which means dad now must ask daughter for permission to sell the property, and daughter is entitled to one half the sales proceeds from that sale. Now for the second main reason. We have incorrect procedures, typically stemming from a lack of legal advice. Many who add children to their title do it incorrectly, which means bringing in a lawyer anyway to solve the problem. First is the matter of vesting. How will you hold title jointly? As joint tenants or tenants in common? Joint tenants means if one owner dies, the other gets the property by default or by operation of law. But if the deed doesn't explicitly mention this, complications arise. In California, any ambiguity defaults to tenants in common understanding, which does not have an automatic inheritance right. Every time we've had an ambiguity on title, it's because the deed doesn't say anything on it besides the names of the owners. There's no language specifying how they are holding title. If it's tenants in common or the deed doesn't say, then when one of the title holder dies, their portion of the property stays in their estate, meaning probate court involvement is required. Next, we have transferred portion concerns. Sometimes parents believe they've transferred a certain portion, like half of the property, only to find out they transferred less. This misunderstanding can further complicate the probate process, for instance, probating 75% of a house. We see countless cases where parents add children to title hoping to simplify matters, but end up creating more complexity. If you're considering this, my advice is twofold. Number one, just don't do it. Number two, talk to an estate planning attorney. Understand the repercussions before deciding. If you choose to proceed, ensure the deed is legally and correctly drafted. Estate planning attorneys, like us, frequently rectify mistakes stemming from parents adding children to title. These issues may be lucrative business for us attorneys, but they're a headache for the family. To genuinely simplify things for your children, consider creating a living trust. But if you still want to add them to the title, at the very least, consult with an attorney. Let's make informed decisions for a secure future, all right? I hope this video shed light on a critical topic in estate planning. I'm attorney Andrew Bethel, guiding you to make the best decisions for you and your loved ones. Drop a comment below if you have any questions. Don't forget to like and subscribe if you found this video helpful, and check out our other great videos. Stay informed, and I'll see you next time.